my primary practice is to work mostly with the nearshore Latin American companies coming to the US and keep them out of trouble and making sure that you guys, the buyers in the room, are hiring good, sophisticated, legally proof ready companies. I am going to talk about a new American law called the Corporate Transparency Act. And it's a significant law because if the first federal law ever in this country that touches on issues that have been traditionally things of state law, which is formation of companies, right? So let's talk about this. This is the very first time that the federal government says, I want to know who owns the LLCs that people keep opening on LegalZoom or any other website. Everybody can go online and form an LLC, Delaware, anywhere in the world, and anywhere here in the US. It's very easy. And the federal government, with everything going on with terrorism and money laundering and Russia and Ukraine, they're curious about who are these people. So how many of the nearshore companies have either an LLC corporation in the US? Most of you, yes. And it was probably easy. Whenever you went to form it, you probably asked the person, do you need my ID? Do you need my passport? Do you need this? And our answer, if you did it with a lawyer or online, we're like, no, I don't need to see any of that under Texas or any state law. You just give the person your information. We trust that you're giving us truthful information, and then we file. 2 days later, you have your company. What happens? The federal government is saying, well, LLCs and corporations are formed under state law, right? So the federal government has no idea, for certain companies, who owns those companies, who's behind them. The federal government has no way of knowing if that asset is under an LLC, who owns that LLC. Because even the states don't know that. Nobody knows. The federal government wants to know what is going on. Because when we try to fight crimes like terrorism and all these ugly words on the screen, they don't know where to go. They have to go to the state, and the state needs to subpoena somebody, and we can't fight some of those crimes. So the government is saying, we want to know. The organization within the federal government that wants to know all this information is called the FinCEN, is the Financial Crimes Enforcement Network. It is an arm of the Treasury Department, so who you pay taxes to, they want to know more of what you're disclosing. Not everybody has to report this information. You only have to report, and I'll tell you what you have to report, if you are a reporting company. But here's the fun thing. Who's a reporting company? Well, under the definitions, every LLC and every corporation is a reporting company. If you have a US LLC or a corporation, partnership, and some other types of organizations, are you a reporting company? I'm telling you right now, yes, you are, okay? And we'll talk a little bit about some of those exemptions. There are 24 exemptions, and most of them will apply to probably some of the buyer entities here, large organizations that have millions and billions in revenues or that are highly regulated, for example, banks, insurance companies, certain companies that are already, because of the virtue of the nature of their business, they already report and are under other laws that already require them to tell the government who they are. So the government is not worried about those. They're really worried about the smaller companies, the ones that are easy to form in certain businesses. So let's talk about one exemption that will probably apply to those nearshore companies here, but not for sure. If you have, again, let's go back. If you are a US LLC or corporation, you're a reporting company, unless you are a large operating company under the regulations. Let me start with the middle, what you have here in the middle. There are these three elements, you have to meet them in order to be exempted from reporting. And being exempted from reporting meaning you don't have to report. If you're not exempt, then you have to file this report. So the first element that I want to talk about is the one in the middle. So if your company has $5 million in revenue, so receipts, in the US, so excluding any other revenues from other, sourced in other countries. So if your revenue is $5 million or more from sales in the US, as shown in your previous income tax return, then you met that element of the 5 million. And that actually includes, if you have a subsidiary, you can add that subsidiary's number to the company here at the top, right? The one you're now analyzing. You have to have more than 20 full-time employees in the US. So I have many, many clients who have hundreds of employees abroad and have way beyond 20 million. But probably none of them have 20 full-time employees in the US. Now, these are extremely legitimate. There's no worry about any of them being in any blacklist or anything. These are, you know, perfectly fine business entities. But the government is saying, in my view, completely out of sync with what happened with COVID and everybody going remote, right? And the mode of hiring independent contractors, which is very common in this industry. Well, the government wants to see 20 full-time employees in the US. And they're being very strict about how you count a full-time employee. A full-time employee is somebody who works under the IRS rules full-time. Like, that's it. You're a W-2, you're getting paid a salary, okay. So I would bet many of you have maybe you have 10 salespeople in the US. And they do work full-time, but you have them as contractors. They don't qualify. So that I feel many companies are going to fail. And unfortunately, you could have 100 million in revenue. I don't care how much. Completely legit, but the government will want you to report. So there we go with the first prong. Now, the last prong, which is, again, so out of sync with today's economic reality, is that you have to have a physical presence in an office in the US. Again, completely ignoring, in my view, that we have a remote workplace. I think that hits this particular industry strongly. You could have, maybe you do have 20 employees. Maybe you do have 100 million in revenue or 10 or whatever your number is. But if you don't have an actual office that is not a house and it's not a shared space, so if you hired work, what's the name of that? WeWork or some of the other ones, if your office is there and it's a shared space, doesn't count. Now, here's the good news. This law is in effect today, but the regulations that implement the law have not, is not in effect yet. This law applies not only to LLCs or corporations that you form from the date that the law was passed or when the regulation started, but it goes back to eternity like if you formed an LLC 20 years ago, the government wants to know who you are. You're concluding today that you are a reporting company. What's next? What do I do? Okay. There are 3 categories of information that you need to report. Information about your company, information about the beneficial owners, and information about the applicant. That's a person who's going to actually assume a lot of responsibility because the government wants to know. I want to talk about the beneficial owners because the beneficial owner is technically who owns this LLC. Well, I'd say under the government's kind of wording, kind of everybody who in any way can control the activities of the company. So they say 25% ownership interest. That's going to be the shareholders, whoever the founding partners are, assuming they have 25% or more. But I don't like how they say directly and indirectly. And I don't like how they say substantial control. Because for me as a lawyer, substantial control means one thing. And if I get Camille Vasquez, that superstar lawyer, that will mean something else to her because lawyers disagree all the time with each other. So you bet there will be 10,000 definitions of substantial control. But let's just talk about some of the basic ones that probably apply in this room. So obviously the shareholders with 25% or more, the board of directors, the ones that are voting and saying, I approve that decision, I disapprove that decision. Even if they're not a shareholder, they're exercising substantial control. So they're on the hook. Then they're going to have to be on this list of a beneficial owner. So these might lead some companies to restructure their decision making to maintain as much privacy as you can. What about if I'm an LLC, I wanted capital, and I have private equity. They bought a 30% interest in my company. It's above that 25, but we have private equity in the middle, probably a beneficial owner. What about people with any kind of convertible instrument where they're giving you debt, whatever? It can get interesting. So the simpler you get it, the less reporting you'll have to do. I think that's the bottom line.